Good morning. My name is Malcolm Niekirk. Welcome to Fretton's 9th coffee break briefing of 2023. This is actually a small milestone for us, as this month is our 3rd anniversary of our first coffee break briefing. Yes, we've been putting these on for 3 years now, and I'd like to pay tribute and thank those who have been working on them behind the scenes for all that time. So big shout out to Jenny, Cameron, Lewis and Kira. And a big thank you too to those of you who are listening to this. I'm grateful for your support. I originally intended to run these for only a few months, but while the audience is staying, so will I too. And I'd also like to extend a particular welcome to those of you I saw at the SESCA Insolvency Conference at Denbies last week, which is one of my favourite conference venues. Although I have to say, I'm not quite sure why you're here now, as I'm simply going to repeat one of the presentations I gave there, but you'll be very welcome to stay if you'd like to do so. Now, as is traditional at this stage, I will give you another reminder to try out the retention of title website tool I showed you earlier this year. Why not scribble down a quick note to yourself to have a look at it at the end of this morning's presentation if you've not already done so. And please let me remind you that I do pre-pack evaluations. I was doing one a month in the first half of this year, but it has been quieter over the summer. Several people I've seen recently have told me they didn't know I was an evaluator, so you might like to note down that I'll be happy to give your buyer an estimate if you are selling to a connected party soon after your appointment. So welcome to today's coffee break briefing, when I will be talking about the government's proposals for the future of insolvency regulation. These are new proposals which were published only about 4 weeks ago, so it seemed timely to refer to them now. So I'm going to start with a slightly random photograph of a lotus. Why a lotus? Well, it gives me a chance to give you this quote attributed to Colin Chapman, who was the chief engineer of Lotus Cars. He is reported to have said that any fool can build a bridge that doesn't fall down, but it takes a skilled engineer to build a bridge that nearly falls down. And of course, the significance of that quote is that it demonstrates the balance that applies just as much to regulation between making sure that the system isn't over-engineered so as to impede the work that has to be done by those who are regulated, whilst at the same time ensuring that it is robust enough that it will deal with the issues. It's probably not possible to build a perfect system of regulation. I suppose the best we can do is to try and improve what we already have got. And I think it's fair to say Colin Chapman probably didn't always get it right either. Allegedly, Lotus is an acronym standing for lots of trouble, usually serious. Anyway, on to the main topic, which is about the future of regulation. And there's a case study that I would like to start by talking about. And these are all facts that are in the public domain and indeed on the Insolvency Service's own website. It's the practice Savants, which was essentially a one-man practice by an IP called Adrian Duncan. And he had a difficult relationship with his regulator over the years, which culminated in him being prohibited from taking on new appointments. So he retained his insolvency license, but he was not allowed to take on any new appointments, and he was expected simply to work through his existing caseload pending further review. But his regulator failed to monitor his compliance with that prohibition, and it turned out that he was in fact taking on new appointments despite the ban on him. And by the time events caught up with him and his practice was closed down, there were about £4 million missing from estate funds, as indeed is Mr. Duncan himself. This then resulted in the first ever formal reprimand being issued by the Secretary of State to Mr. Duncan's regulator, ICAEW, and that was picking up on those two issues in particular. The fact that the regulator had failed to notice that he was continuing to take on appointments despite the ban on him, and the fact that they didn't take more steps to ensure that there were proper controls of the funds in the estates, which might have mitigated perhaps against some of the money that was found to be missing. So that example is quite a useful illustration, and I'm sure that it's one that will be considered by both regulators and those within the insolvency service who are looking at regulation in thinking through how to implement the proposals that have been published. And it shows, for example, how the Secretary of State is acting as the regulator of the regulators. It shows in terms of how the reprimand was issued, the use of the statutory regulatory objectives, and the fact that the reprimand was issued because the Secretary of State considered ICAEW to be falling short of the regulatory objectives. And it also highlights the significance of bonding in terms of its importance as a compensation scheme for those who miss out when events like this happen. I'm now going to take you back through the recent history of regulation to talk you through what led to the government issuing their proposals 4 weeks ago. So we'll start in 2015 when there was legislation that introduced the statutory regulatory objectives that govern the profession now, and also gave the Secretary of State the job of being the oversight regulator, the regulator of regulators. Now, interestingly, the legislation at that time did include the power for there to be a single regulator to replace what it was then 5 RPBs. But that power had a sunset clause on it, and it actually expired about 12 months ago. So that statutory power to set up a single regulator no longer exists. Now you can see there was a 7-year timetable there that the Secretary of State was working to, and about halfway through that, in the summer of 2019, they issued a paper calling for evidence about regulation, essentially asking interested parties, is regulation working, and should we use that power that we have to establish a single regulator? The Secretary of State listened to the results of that call for evidence, and 2 years later issued a consultation paper that set out a number of proposed changes, and again asked the more detailed question of interested parties: are these changes sensible? Should we implement them? And the issues that were identified and listed in that consultation paper were that it was considered that there were too many regulators, down from 5 to 4 at this stage, but still it's a small profession to have 4 regulators governing it. Second issue was the perception of conflicts in some cases between firms who employ insolvency practitioners and the insolvency practitioners working within those firms. The issue where the insolvency practitioner is perhaps responsible for ensuring regulatory compliance, yet if they're not on the board of the firm that employs them, they may not have sufficient control over their purse strings to ensure that compliance can be achieved satisfactorily. Third issue was the question of a public register of insolvency practitioners. And the fourth one was questions about bonding and whether bonding should be replaced by some other type of compensation scheme, whilst perhaps suggesting that that could take some time. So maybe there should be some provisional interim changes to the bonding system while that is considered. The options that were presented as being the likely direction of future regulation in that paper are listed on this slide and the next one. The most open question, I think, was the one about the regulators, where the government suggested there were 3 ways in which a single regulator could be set up. They could either make one of the existing RPBs the single RPB for the profession, with the other 3 then losing that status of being an RPB, or they could set up a new body as the independent single RPB, in which case the existing 4 would all lose that function. Or the third option, which is the one that the government preferred, would be to set up a new government-run regulator. So those were the 3 options that were presented. There was a clear steer that firms employing insolvency practitioners would need to be regulated, as well as insolvency practitioners still needing to be regulated, and that firms operating in high-risk categories would have an enhanced regulatory regime applied to them. In terms of the public register of IPs and firms, there is, of course, a database that's available on the internet from the government's insolvency service, but this would be a more formal statutory register, and it would also note when IPs and firms had some degree of disciplinary sanction applied to them. When looking at bonding and issues related to that, the government thought that the power of the regulator should be expanded to give them the ability, when applying a sanction to firms or insolvency practitioners, to order the firm to pay compensation as well, with the suggestion there should also be a compensation fund, so that in cases where firms fail or are unable to pay the compensation that they're supposed to pay, the hat will be passed around the profession to make up what is due to the complainant. The regulator, of course, will be funded by the profession as well, so there will be a further levy to pay for that. And on the question of bonding, the suggestion that this could be done with better bonds than we've got at present, or with a different compensation scheme, which might be brought in with a single government regulator. There's also the suggestion that, as perhaps at least an interim measure, the regulator should hold a bond of last resort. So in cases where perhaps the insolvency practitioner has failed to bond all of their cases to the full extent that's required, there would then be a fallback position for those who've lost out to make a claim. And then we come to the present day, and the responses went into the Secretary of State to that consultation. They've been considered, and the government have now published their formal response to it, which is a clear direction as to the way that policy is going to go in this direction. The big issue, of course, is about a single regulator, and the consultation response suggests that this was broadly considered to be a good idea, but for various reasons, it was felt that the single regulator should not be the government's preferred proposal of having a government-controlled regulator, but it should be a single independent regulator. So that's the way it's likely to go, with a new single independent regulator being set up. But the response suggested that legislation is probably going to be necessary for that. Now, my own personal opinion, for what it's worth, and I don't think that it's worth any more than anybody else's opinion at this, is that I think it might be possible, if there was will there from all sides, for the 4 RPBs for the 4 RPBs to delegate and effectively set up a new single agency that does the work of all four of them. There is a precedent for this in that the Law Society was a regulator. Pardon me. The Law Society was a regulator of insolvency practitioners. It stopped doing regulation of insolvency work a little while ago, but as an interim measure, it did actually delegate its regulatory authority to the SRA, which the Solicitors Regulation Authority, which was an interesting move because the Solicitors Regulation Authority was not a statutory regulator for insolvency work. And this was done simply by agreement between the Law Society and the SRA, and I would imagine also the Insolvency Service. So if that has been done in the past, it may be possible to do something similar in the future and set up a single independent regulator by agreement between the existing RPBs and the Secretary of State without the need for legislation. The consultation also looked at the regulatory objectives, the statutory guidelines that are set for the regulators, and they suggested that there's no big changes needed there in the medium term. There may need to be some changes made to those regulatory objectives when the policy objective of regulating firms as well as individual practitioners comes into effect. And there may be some slightly larger changes when there is a single regulator, but broadly speaking, the regulatory objectives will remain as they are. There may be a change to the way that SIPs are issued, because the Insolvency Service are very keen that the Secretary of State should take over the job of setting ethical and technical standards. I think this is to ensure that there is perhaps not a conflict of interest that you might have if the regulator were to be setting standards as well as seeing to enforce them. So I think the idea is that it should be one body, one organization, one entity that sets the standards, and a separate one that then has the job of enforcing them. Again, the consultation suggested that legislation may be needed to achieve that. I'm not so sure. I think that SIPs presently are issued following consultation between the Secretary of State and the RPBs, and I'm sure that consultation will continue, and I don't think it would be a big difference, a big change for the SIP then formally to be issued by the Secretary of State rather than by the RPB. Regulation of firms is certainly going to be the way forward. Sole practitioners, so where you've got a single insolvency practitioner who is operating on their own, they will not need their firm, which is essentially themselves, to be regulated separately from themselves as an individual IP. But for practices of any larger size, then the firm itself will have to be authorized and will be regulated as well. The firm will be barred from taking on insolvency work unless it is authorized and regulated, and will have to nominate a compliance officer who I suspect will have to be board level, but need not be an insolvency practitioner themselves. Now, I suppose the big question is, how long might it take for all this to happen? If it were that the RPBs got together with the Secretary of State to create a single regulator by delegating their existing responsibilities and powers to a new body, I think I've got a suggested timetable of 12 months to 2 years on the slide. Probably be the longer end of that time, I suspect, but I think it could happen relatively swiftly. A statutory single regulator would take rather longer, and of course it's highly likely there will be a general election during 2024. There may well be a new government. New government may have different priorities in terms of a legislative timetable, and sorting out regulation of the insolvency profession may be somewhat further down the priority list than it might be at present. So I think it could actually take quite a few years before we see a statutory single regulator, which is why I think it's quite possible that the RPBs and the Secretary of State may cobble something together by agreement sooner than that. I think that for the Insolvency Service to take over issuing SIPs and similar ethical and equivalent guidance could be done relatively quickly, perhaps within the next 12 months or so. Regulation of firms. Again, my own view here is that it might be possible to get much of this done with what would be in effect a new SIP, requiring insolvency practitioners who are not sole practitioners, who are working within a firm, to ensure that their firm is authorized and regulated, effectively registered with a regulator, and gives undertakings for compliance to that regulator. It may not be as slick and as sophisticated as if it's done with legislation, but I think it could be done rather faster that way. Again, we have the issue that for legislation to go through Parliament, there will need to be legislative time available, and that may not be available if there's a general election and a new government. The reforms of the bonding regime may be easier to achieve, as I think that could probably be done with secondary legislation rather than primary legislation, but I suspect it could be many months, perhaps a couple of years, by the time the legislation has been drafted and implemented. So that's a quick look through the proposals that are likely to be coming into force at some point in the future for the regulation of the insolvency profession, and my best timetable as to when it may be. I don't see any questions, so I'll just give you the dates now for some future events. That's today, the coffee break briefing. Next month's coffee break briefing is likely to be on Barclay Applegate orders, which are what you might be looking at in cases where you're taking over an estate where there may be third-party assets like a client account or something of that sort that needs to be sorted out, needs to be dealt with, and the circumstances in which you're going to have control over that client account, and circumstances when you might need to go to court to get a Barclay Applegate order to give you control over that. And at some point next year, date and venue yet to be confirmed, there will be our 3rd annual insolvency conference, and I hope to see many of you at that. That brings today's presentation to an end, so thank you all very much indeed, and look forward to seeing you at next month's coffee break briefing, if not before. Thank you.